As part of their cross-examination of witnesses in the trial for electoral fraud, Donald Trump's attorneys want to use secret papers. According to court filings, Trump's legal team has already informed Judge Tanya Chutkan in Washington, D.C., that they intend to present classified documents to prove that Russia, Iran, and the Lebanese militant group Hezbollah attempted to influence the 2020 election and that Trump attempted to thwart their efforts. Attorneys for Trump, Todd Blanche and John Lauro, filed a mysterious document on Tuesday claiming they want the secret materials in order to question witnesses or to testify themselves. While we continue with this video, we kindly ask that you please subscribe and then hit the bell icon to stay updated. They informed Chutkan of their intention to question someone mentioned in the records using the documents. Is it appropriate for any of them to provide testimony about those people during the trial or to question other witnesses about them? Because the system for processing requests for secret documents is not accessible to the public, the attorneys could not include detailed information in the submission. On November 8, top prosecutor Jack Smith sent confidential materials to the defense through a designated official. These records were the subject of their reference. After reviewing the materials, Trump's attorneys will need to petition the court to utilize them during his trial in March of next year. It is probable that Smith's office will resist the request to utilize the materials at trial. Since the Supreme Court has officially stated that Section 3 of the U.S. Constitution permanently bars Trump from running for president again, he will not run for president again. If you're looking for some good news, you should definitely keep watching to the end. Courts in 3 states, Colorado, Michigan, and Minnesota, have so far declined to resolve arguments that Donald Trump should be disqualified from running for president again under the 14th Amendment's 3rd section. Plaintiffs in Michigan and Colorado have sued Mr. Trump, alleging that he should be disqualified from serving as a U.S. official because, according to Section 3, he was an officer who, after swearing allegiance to the Constitution, rebelled or insurrected against the country or helped its enemies. Both Mr. Trump and his team have consistently denied the claims, painting them as baseless plots to derail his political aspirations, especially in the lead-up to and during the assault on the nation's capital on January 6, 2021. Many legal experts and election officials who were against the former president have also spoken out against these efforts. According to Brad Raffensperger, the Secretary of State of Georgia, using Section 3 is just the most recent attempt to prevent people from casting ballots. Michael McConnell, a former judge and lecturer at Stanford Law School, argues that removing Mr. Trump's eligibility to vote on questionable grounds would lack legitimacy. These critiques do not adequately address the reasons why Republicans were adamant about including Section 3 of the 14th Amendment in the Constitution after the Civil War. Despite being mostly ignored for the last 150 years, the problems it poses are still relevant and important to maintaining our democracy. Republican framers and ratifiers of the 14th Amendment saw Section 3 as a critical safeguard against the disenfranchisement of voters by advocates of political violence. Since the Civil War, there have been few instances as tragic as the events of January 6 and the attempts to overturn the 2020 election, which disenfranchised millions of Americans. The fact that this provision has been silent for 150 years is due to the nature of politics as usual, not a lack of proper application of the Constitution. But we do have Section 3 at our disposal, which allows us to evaluate the current candidacy of Mr. Trump. Soon, we will determine if Mr. Trump is eligible to run for president again, potentially reshaping our perception of democracy through the possibility of constitutional disqualification. Many people who are against using Section 3 now think that unless Mr. Trump does something as horrible as bomb Congress, he shouldn't be held accountable under the Constitution. Have you any thoughts on this matter? Please share your thoughts and opinions in the space provided below. However, they argue that upholding constitutional standards may irritate Trump's followers, potentially leading to political bloodshed after the Civil War. These were points that Republicans had heard before. In 1866, proponents of racial segregation and slavery voiced their dissatisfaction with a lack of voting rights and stoked worries about future political unrest. During discussions regarding Section 3, liberals and a small number of extremely conservative Republicans in the 39th Congress argued against denying white Southerners the opportunity to vote for Confederate leaders. Senator James Guthrie of Kentucky stated that the people in that region of the country still had faith in those individuals who were prohibited from seeking public office. According to many who battled against the 14th Amendment, extending the right to vote to traitors could result in a new civil war happening in the United States. Senator Edgar Cowan of Pennsylvania issued a warning on the possibility that Section 3 could incite a new rebellion. White nationalists were a source of hatred for Republicans during the Reconstruction era because they misused democratic ideas for their own personal benefit and posed a threat of violence when they did so. Representative Thaddeus Stevens warned the Republican Party that vocal secessionists and covert sympathizers would inundate them if they did not rewrite the fabric of constitutional politics through amendment. If former Confederates and their allies were to lead the way in making the 13th Amendment a mere formality, the accomplishments that the Union won during the Civil War would be eroded. Those individuals who had previously sworn allegiance to the Constitution but had subsequently taken part in acts of revolt or insurgency were, in the opinion of Republicans, ineligible for future positions of leadership. The 14th Amendment aimed to ensure that the government would be led by individuals who were trustworthy, faithful to the Constitution, and possessed the necessary integrity for leadership while upholding the rule of the majority. In order to accomplish this objective, one strategy would be to prohibit public servants from violating the oath of office they have taken. It is important to note that the constitutional oath of office and the disqualification for rebellion are closely related. An insurrection was an organized effort to defy the efforts of the government to enforce the law by resorting to violence or force. This was the definition of an insurrection for Americans living in the 19th century. Under this interpretation of Section 3, public officials, whether they are currently serving or have previously served, who actively strive to amend the Constitution are exempt from its provisions. This is the case regardless of whether they are working to undermine constitutional democracy or advocating for its repeal. Section 3 would prohibit both fundamental civil rights and long-term officials who wish to be undermined by violence, as well as those who desire to be undermined by violence. In the year 1866, the Republican Party recognized the significance of racial equality, also known as racial justice, as well as the fundamental principle of free labor, which advocates for men to rule society via mutual agreement rather than social rank. Reconstruction Republicans considered Section 3 a liberating tool that empowered the people, instead of mobs, to determine the conduct of constitutional politics. This was a significant advancement for the Republican Party. Those in authority, both in the past and in the present, who guided the South to secede were betraying the will of the people who had voted for Abraham Lincoln, who had vowed to put an end to slavery once and for all. Political leaders who choose not to execute the constraints of Section 3 out of fear of violence would counterproductively hinder the goal of that amendment to the Constitution. The Supreme Court justices who were responsible for drafting the 14th Amendment were of the opinion that no politician, from Jefferson Davis all the way down to Donald Trump, should be able to employ the threat of physical force in order to obtain election to that office. There is not a single person who is dissatisfied with decisions that prevent Mr. Trump or any other revolutionary from attaining public office. A candidate who supports the mix of policies that Mr. Trump argues for can receive votes from everyone, including those who are supporters of Mr. Trump. Following the passage of the Amnesty Act in 1872, the only thing that prohibition does is prevent voters from choosing politicians who, in the event that their ideas are rejected by a valid vote, would then either riot or assist others who would riot in order to overturn the outcome of the ballot. The provision of functional or legal amnesty to Mr. Trump today ought to be accompanied by a cautionary discussion of the consequences of pardoning former members of the Confederacy. A great number of federal and state officials who had violated their promises of allegiance during the Civil War were able to return to their jobs after the 1872 Act made it possible for them to do so. State authorities either participated in or dismissed the terror operations against ethnic minorities, resulting in decades of Jim Crow disenfranchisement. The Select Committee investigating the attack on the Capitol on January 6 acquired public evidence that clearly argues for preventing Mr. Trump from casting a ballot in the election. As a result of an order from the President of the United States at the time, the protesters were present inside the halls of Congress. The judge who presided over the case in Colorado, Sarah Wallace, came to the conclusion that Mr. Trump had willfully disobeyed the Constitution. Dave Williams, a senior executive at Deutsche Bank, provided testimony on Tuesday in the civil fraud trial of former President Donald Trump, which is being held for a considerable amount of $250 million. On the basis of the questionable fact that Section 3 applies to all public officials, with the exception of a president who has never held any other public office, the judge decided not to exclude him from that category. However, it is astonishing that this fact remains. Due to the complexity of the undertaking, there is no method that can be considered absolutely certain for determining Trump's exact net worth. Williams, a specialist at Deutsche Bank, stated that determining the precise value of Trump is inherently subjective due to the personal nature of the individual. In response to a question from Trump's legal team about accurately estimating the former president's net worth, Williams expressed skepticism. Williams stated that the claimed net worth of an individual is subjective. This witness's statement lends support to Trump's case, which refutes allegations that he deceived financiers by exaggerating the value of the Trump Organization. This notion is highly disagreed with by Letitia James, who serves as the Attorney General of New York State. In addition, Williams detailed the precautions that Deutsche Bank took while determining the value of Trump's assets. During his presentation, he brought up the fact that we anticipate our customers to provide genuine information and that they are taking a more cautious approach while conducting their evaluations. On the other hand, audits of these financial statements are not a typical practice in the respective industry. At this point in time, I believe that it is essential to have a variety of perspectives. The statements made by the CEO demonstrate how difficult it is to place a monetary value on the wealth of a high-profile individual, particularly one such as Donald Trump, who has a collection of businesses that are both diversified and complex. There is a great deal of ambiguity involved in estimating a person's net worth, which casts doubt on the reliability of financial reports and the integrity of lending organizations. As a result of the disqualifying incident, Donald Trump becomes overwhelmed with emotion. Furthermore, in addition to all of this, feel free to share your thoughts in the provided space. To show that you found this video to be extremely beneficial, simply give us a thumbs up.